Hi, guys. It's Kathy. I hope you're doing well. I hope you took your blood pressure pills if you have them. And I see my age group of people who watch my videos, and you all have blood pressure pills. I hope you took them. Mark Furman's on the stand for, I see him here, I see him here. And is that lying? No. Phillips. Is that Phillips or, anyway, I don't know. It's either Phillips or Van something. I can't remember right now. It's not coming to me. But we're moving to him next. So we will not get done with Furman today, but we will get done with Furman tomorrow. If they're going to play a tape about Furman, oh, you know what? 2 videos ago, they limited my monetization on that OJ because they dropped the N word like I don't know how many times. Too many. One is too many. So YouTube said, nope, we're not having it. But hopefully they don't do that again today. There looks like there's a spike in this one though. So if I had a guess, if no, that doesn't look like they're listening to a tape right there. It doesn't. I don't know who the heck is that guy. It doesn't matter. We're gonna find out. Here we go.
All right. All right. Now you attach some significance, as I understand it, to the Bronco. Initially, against the possibility that people inside would be injured, correct?
Yes.
You had ascertained by questioning Cato Kalin that only OJ Simpson drove the Bronco, correct?
Yes.
And you had noticed a shovel and some plastic which you did not then understand in the back of the Bronco, correct?
Yes, sir.
All right. And you have before cited this set of circumstances as being relevant to the pressing need to go over the fence onto the property, correct?
Yes, sir.
All right. Were they also relevant to the possibility that Mr. Simpson should be looked at as a suspect on the 13th of June?
Not at the time as you are describing these, no.
Okay. When you learned that he was the only driver of the Bronco, according to Mr. Kalin, were you interested to know whether the Bronco might have left the premises that night during the period during which the murder may have occurred?
That would have been helpful, yes.
It would have been helpful. All right. Now, when you spoke to Ms. Lopez to get permission to go back along the borderline and wherever it was you wanted to go on the Salinger's property, did you ask her any questions whatsoever about the Bronco?
No.
Or any questions whatsoever about the doings at the Simpson place the night before?
No.
Okay.
All right. So he went to the next door neighbor's house and Lopez answered the door. Rosa said, absolutely. You can walk down our backyard and look and see if you can see anything. Right? Did he ever go to the other neighbor on the other side and walk down theirs too? Or did he only go on the side where the glove was magically there?
Did you then go and make an inquiry or investigation of the terrain to the south side of the Salinger property, along
Yes.
the fence?
Yes, sir.
By the way, did you ever identify yourself to Rosa Lopez
Yes, sir.
as Detective Furman?
Yes.
Okay. Did you take any notes when you talked to her,
No.
or make any later on of the conversation?
No.
And did you ever say to her that you would have some other officers get in touch with her?
No.
So,
Yeah, it's a corner house. So like it's on the corner. And he went to this neighbor over here. But did he go to this neighbor over here?
so as far as you were concerned, there was no point in you or anyone else questioning Rosa Lopez.
There was nothing she indicated that should be interviewed for, no.
Well, you never asked her a question. How could she indicate anything?
As far as I'm concerned.
Do you determine without asking questions whether witnesses have information?
No, sir, you misstated. I wouldn't have interviewed her.
You would not have interviewed her.
No.
As a detective, you don't interview witnesses?
It was no longer my case. Detective Lang and Van Etter will dictate what interviews and when.
Did you ever consult with them?
Maybe, or behind, but if like it's a curve, that corner, all right? And here's OJ's house. And there's this street, and this is the neighbor's house right here. But this street keeps going. There's a neighbor here. So Furman, nope, that's wrong. That's wrong. It's fine. Furman saw the Bronco here and then decided to go over here and go down here to find the glove. But did he go over here at all to this neighbor, which is closer to where the Bronco is parked? I don't know.
And say, I'd like this time to ask you a direction. Should I talk with this lady next door?
No, Detective Lang was on the Bundy crime scene, and Detective Van Etter was writing a search warrant.
You couldn't interrupt him writing the search warrant to see if it was okay to talk with the next door neighbor's maid?
I didn't think it important.
Didn't think it important. Did you cause her to ask her gardener some questions?
Excuse me?
Did you cause Rosa Lopez to ask her gardener some questions?
Not at all.
Were you looking for possible sharp objects when you were on the Salinger property?
I was looking for anything that looked like it was unusual or something that was obvious.
Was one of the unusual things you were looking for, Detective Furman, a sharp object?
Cato, that's why. Cato, who lives back there on that side, said he heard a loud bump that night. So that's why he went around that way. That's why he went into the neighbor's yard. The other neighbor didn't say, oh, I heard this or whatever.
I didn't know at that time the cause of death at Bundy, so I didn't know what I was looking for precisely.
Can you answer the question? Were you looking or were you not looking for a sharp object?
I can't answer that as a yes or no, sir.
So you don't know if you'd seen a knife, whether you'd have picked it up or photographed it or even noted it?
I wasn't specifically looking for a knife. If I would have found one, I would have seized it, yes, or kept it there for a photographer and a criminalist to recover, yes.
Okay. Now, what else were you looking for? If it wasn't knives, what were you hoping to find?
I don't know, sir. Anything that looked like it was out of place or possible evidence. I could go back to the Salinger residence and ask if it was theirs.
All right. Bloody clothing?
Anything of that nature, yes.
Had you seen enough of the crime scene to assume that whoever had perpetrated the murders probably had blood on them, as the gloves did?
Yes.
All right. Were you interested in finding whether or not there was any bloody clothing nearby the Simpson residence?
I don't think I was specifically looking for just that, but as I said,
Detective Furman, when I ask you if you're looking for something, that does not mean to the exclusion of all other items. I simply want to know if that was on the list of things that might have interested you if you had seen it.
there was no list.
There was no list.
No.
It's
Okay.
not that hard, sir.
You know-
He's investigating. He just is looking. That's what he's doing. He's looking. If he finds something, that's great. If he doesn't, that's great. He's just looking. Anything, for anything.
How you were going to decide whether something was significant if it walked up and hit you in the face?
Well, if it didn't belong in the Salinger residence and it came from the Simpson residence, it could be possibly construed as something involved with anything to do with Bundy or Rockingham, and I'd simply ask the Salingers.
Well, my question to you was simply, included among those kinds of items, would bloody clothes have been an item?
Yes.
All right. Did you find any?
No.
Did you find any sharp instruments?
No, sir.
Was the gardener working that Monday morning?
I saw a gardener sometime that morning, but I'm not sure if it was in front of Salinger's residence or on the street.
You never saw the Salingers there, did you?
I don't believe so.
The only person you spoke to at the front door was rather short, Hispanic, upper middle age, correct?
No, because I believe there was a security door with some type of a mesh where I can't see in. That person opened the interior door and spoke through that.
If the person who spoke to you that morning presented themselves in this courtroom now and didn't say anything, would you be able to recognize them?
No.
Was the accent accompanying the voice, which had no image at that point, Spanish or Hispanic?
I don't recall that there was a heavy accent, no.
Do you recall any accent that would tend to identify the speaker as someone born in another country?
It's a possibility, but I don't recall it.
Okay. And when was the first time you ever spoke to anybody about this encounter with the person at the Salingers?
I believe when Rosa Lopez came forward as a witness.
Well, you mean when she was first listed by the defense, a long time ago or recently?
I'm not sure on that, sir. I don't know when she was listed, and I don't know when she testified exactly, so I would probably say sometime in between there.
Did you ever learn, as a result of any hearings before this court, without going into what was said, that it was alleged that you had talked with Ms. Lopez the morning of the investigation, the first morning?
Yes, I heard that.
Do you remember when you first learned that?
No.
Have you ever made any effort since that time to get a look, Ms. Lopez, to see whether or not, or listen to Ms. Lopez, to see whether or not you could recognize that person as the one you may have talked to on the morning of the 13th?
Yes, I saw her on the news.
All right. And did you listen to her?
Yes.
Did that help you in any way as to whether or not this is the person you questioned on the morning of the 13th?
Well, she was speaking Spanish, so no.
All right. You did not hear her speak English?
No, sir.
Did not hear her here on the witness stand testifying?
No, I saw a clip on the news. I believe it was of her testimony.
Okay. All right. And to this day, by the way, do you know what, if any, portion of the neighborhood around the Simpson home was searched for these items of evidence that you and I have been discussing, such as weapons and clothing?
No, sir.
You never participated in, gave any direction to other officers about, or otherwise involved yourself in a search for items of evidence of this sort?
I was there during the search warrant, and I assisted in the closet of Mr. Simpson's bedroom and some of the exterior portions, but that's it.
Who was the first person, if you know, by the way, ever to go up to Mr. Simpson's bedroom after you entered the premises?
I don't know, sir.
What time did you go there first?
Inside the residence?
Yes.
With Mr. Kalin.
How great an area, if you know, around Bundy was searched for bloody clothing, other accoutrements might have been worn or used by the murderer, including a weapon?
I have no knowledge of that, sir.
Didn't Officer Risky tell you where he had caused people to look for items of that sort?
I don't recall that, no.
All right. Did you continue working on this case after June 13th?
I believe I was asked to do a few things. Yes.
Did you know that Detective Van Adder said on June 6th in his sworn testimony that you were still very much a part of the case as a detective?
Well, I think that would include the times that they ask us to do certain things, yes.
All right. And when did you last do any work on this case, Detective Furman, other than prepare yourself as a witness?
It would have been last year, sir.
I understand.
Maybe a month after the crime.
You think you may have continued through July to work on the case?
Yes, there might have been some things I did, yes.
And some part of August you may have worked on the case?
I'm not sure, sir.
All right, well, assuming that jury selection or proceedings pointed toward jury selection began September 19th of 1994, did you do any work on the case after that?
I can't remember, sir.
You don't know whether you've done anything on the case since this proceeding began?
I don't believe I have, no.
Did you receive an instruction of some sort, Detective Furman?
Guess what he just asked Cochran? Hey, what other dumb question can I ask him over and over and over and over and over again?
To abstain from viewing these proceedings?
Yes.
And have you followed that instruction?
Yes, sir.
Now, over the lunch hour, did you have any chance to reflect or have your memory assisted by any of the minions for the prosecution as to the sessions that occurred before the trial, your part of this trial, and since the first of the year?
No.
Would you say, Detective Furman, that in addition to this being the largest case in which you've ever been involved, this is perhaps the most important testimony in which you've ever been involved?
Sustained.
Have you not been very concerned since January 1 and beyond with the experience of testifying in this case?
I believe I was concerned with the allegations that have been brought forth against me.
Yes.
Yes.
You were concerned with something happening which has now happened, correct?
No, objection.
Sustained.
Withdrawn. Having that in mind, Detective Furman, were you anxious that you deliver a good performance on the witness stand?
Objection, argument.
Overruled.
Vague.
Overruled.
I'm always concerned with that in every case.
In this case more than others, Detective Furman?
I am testifying just like I do in any other case.
Mm-hmm. And have you ever in any other case faced accusations such as you expected in this case?
No objection.
Sustained.
Have you ever in any other case had the benefit, may I finish the question, have you ever in any other case had the benefit of a grand jury case preparation session such as you had here?
Overruled. Denied. You can answer the question.
No.
I thought we already asked that once before.
Okay. Now, having in mind all of that, do you maintain that you have almost no recollection of the sessions intended to prepare you for this testimony?
That's correct, sir.
Overruled.
Have we solved the earlier problem, Your Honor? Described it.
Nothing has been submitted to me.
Well, I understood that it was coming forthwith. Have we learned the status of that, perhaps?
Ms. Lewis?
He's trying to get the glove in. He was supposed to go buy one that's exactly the same size. It still doesn't account for the plastic baggie that Marcia doesn't want in as well. So they're trying to get this glove in so that they could plant the seed that Mark Furman took the bloody glove from the scene and tucked it into his sock.
We use the time profitably.
Didn't want to interrupt the conference of my colleagues.
Wow,
but
you're up early.
I'd certainly like to do that, Your Honor.
Thank you.
Detective Furman, as I recall, your initial arrival at the Ashford Gate and in the developments that occurred thereafter, including the observations about the Bronco, you were concerned that somebody might be bleeding to death, including OJ Simpson, inside his house, correct?
I said somebody. I didn't use the word O.J. Simpson.
No.
Yes, sir.
I'm adding it. Wasn't he one of the people that could have been bleeding to death in the OJ Simpson house?
Yes, sir.
When you got into that house finally and started talking to people, did you ever ask anyone where OJ was?
No.
All right. The only other question I have, Your Honor, is related to that document, which I assume is en route.
All right. All right, ladies and gentlemen, we're going to take a brief recess. This will probably only be about 5 or 10 minutes. Ask you to step back into the jury room. We'll give you enough time for a comfort break. All right, Detective Furman, you can step down. Stay in the courtroom, please. All right, back on record in the Simpson matter. All parties are again present. The jury is not present.
Why are you going to Vegas? Are you going to get married in a drive-thru? You should. You can get divorced right away. But think about that story. I got married once in Vegas, lasted 26 hours, and then we got divorced. Just do it. Just do it. Maybe salty. Why are you going to Vegas? You going to gamble? Are you? I need to know.
I have now received what appears to be a photocopy of a fax. Yes, please.
I'll
Thank you.
marry you for 26 hours. It'll be a great 3 minutes.
All right, I reviewed this, what appears to be a clear and full-size copy of a letter dated September 21st, 1994, addressed to a Daniel Labato of the Northampton Police Department, Northampton, Massachusetts. All right, either counsel wish to address this issue, or do you want to proceed with the jury?
The people have addressed the court on the issue of relevance.
All right, well, I indicated I wanted to wait until I had the chance to read the entire thing, and without any passages being obscure, I'm now ready to hear that. Mr. Bailey.
Your Honor, I believe that the letter plainly seeks to advance the financial position of Detective Furman to the extent that, in seeking counsel, one assumes that expenses and fees would arise. This letter, which proclaims the high moral character of Detective Furman and declaims false accusations of racism, seeks to have police officers, and I believe it went around the country, contribute to make up the costs that had been incurred and were expected to be incurred. It lists some of the salient victories of the Tortolo firm in representing Furman, and claims that Tortolo and Butler had fronted out-of-pocket costs which have already reached over $100,000. But to clear his good name, the costs of experts, investigators, and paralegals continue to mount at a rate we can no longer sustain. Ground one, I believe that any money contributed as a substitute for something that Detective Furman would owe as a legitimate fee or cost of representation, if there were any, is a significant financial advantage to him. Second, he says he's familiar with the letter. I think we're entitled to ask him which portions of the letter he was aware of before they went out. And third, I think we're entitled to inquire whether anything approaching $100,000 in costs had been incurred by September 21, 1994, or whether the United States mails were used for a fraudulent attempt to obtain money by making misrepresentations as to cost.
Oh, they're gonna limit this anyway. For fuck's sake, come on. This is a murder trial for OJ Simpson. Why are we spending all this time on this one detective that was on the scene for 40 freaking minutes total before it got taken from him? Like, none of this matters. So what? He raised money to pay for lawyers. So what? Who cares?
Costs, which recipients would hardly be in a position to second guess.
You want to explain to the court how it is that this letter relates to any bias, interest, or motive as it pertains to Detective Furman's testimony here today?
Yes, I do, because presumably, if his testimony is accepted or admired by the recipients of this letter, the solicitation is still hanging out there. If he can convince them that he's a good guy and he's telling the truth, OJ Simpson's a bad guy, some of this money may come in. But I don't believe in an undertaking of this sort that the result is necessarily essential. It is the purpose of the exercise.
Thank you, Jude. Thank you so much.
Ms. Clark?
That is tortured logic, to say the least, Your Honor. The witness is here in court to present testimony concerning the work he did in this case. He's not here soliciting funds for anything. Number one, this letter is irrelevant to any issue of bias or detective's credibility. Number two, with respect to how monies have been spent in the mounting of the lawsuits for defamation, is privileged. So counsel's not permitted to get into that. I cannot see any relevance to this letter pertinent to this detective's testimony. I mean, it's just absolutely absent.
Well, the issue, as I understand Mr. Bailey's argument, is that there is some potential for financial gain that would impact on motivations to testify or how to testify. Do you want to address that particular?
Not reflected in this letter, there isn't, Your Honor. What this letter reflects is the need to defray costs of legal expenses incurred as a result of lawsuits which were made necessary by the defamatory nature of the false allegations made against Detective Furman. But there's no financial gain involved in that pertains to his testimony. The two are totally disparate. He's testifying here today, and this letter was generated when? Back in September, long before he took this witness stand, in an effort to defray legal costs. His appearance today has no bearing. There's just no connection between his.
Yes, because the things that they're saying, which were absolutely freaking true, were things that happened outside of the OJ case. Was how racist he was in other situations, which he absolutely was. But not the OJ case.
Appearance in court and this letter and the money it seeks to get, and we're talking about defraying legal costs that were made necessary by virtue of the actions of the lawyers for the defense in this case. So there is no gain to Detective Furman in that regard, and it has not been shown that there is any, nor that there ever will be. To the extent that the court sees there is a financial interest this witness has in having at least begun work or contemplated lawsuits for defamation against the lawyers in this case, that has already been explored. And that issue is not illuminated in any respect by this letter, other than to indicate that he doesn't really have the money to pay for these lawyers. I do not see how it can have anything to do with Detective Furman's credibility on the witness stand, especially in view of the fact that Detective Furman never read the letter. This is something issued by his lawyer, the work product of his lawyer, as was the decision as to who to sue and for what to sue them for, was the work of his lawyer. I understand the agency theories, Your Honor. I'm not arguing with that. But this letter was not generated at the behest of Detective Furman, and I think that's an important distinction to make.
Well, when you call something, though, the Mark Furman Justice Fund, and it's issued by your attorney, don't you think that any attorney would send a copy of these things out for approval by the client before they're sent out, especially if you're talking about a nationwide fundraising campaign and the amount of money that takes? I mean, just in postage, you're talking a substantial amount of money.
Well, leaving that to one side, Detective Furman has indicated he's aware a letter went out that he did not read, that his lawyer drafted. But, you know, do we really want to do this, Your Honor? Do we really want to spend 2 hours now talking about how Detective Furman's lawyer is saying he needs to defray legal costs incurred as a result of the defamation suits that may be filed at the end of this case, which have not been filed yet. I mean, is that where this case is going? How far afield do we have to go on this witness? I mean, we have gone way out there with, in the past 10 years, have you ever used a racial slur? And a woman who makes allegations about him 10 years ago, and what other cases he's ever testified in. And, I mean, we have really hit the outer limits here. And this is far beyond the outer limits. This is the twilight zone. This letter really has no bearing on this detective's credibility, Your Honor. It's a letter he himself has not drafted. And I understand what the court is saying. He gave permission for it to go out, but the language contained in it, which Mr. Bailey is going to want to attribute to him, is not his language. So we're creating an unfair inference that Detective Furman wrote a letter, put language in it, and solicited an amount of money that he did not do. This is the work of his lawyer for the purpose of defraying legal costs. And it is privileged material. Especially because Mr. Bailey has now said that he wants to explore exactly how much money was spent and whether $100,000 is a fair representation. I can assure the court that it is, and the paperwork exists, but it's nobody's business. It's privileged.
Mr. Turtle?
Is Mr. Tortolo going to appear and claim that privilege? Or is
Yes,
Mr. Furman going to assert that privilege?
Yes. This is not territory that I think is really proper for Mr. Bailey to explore with this witness. You know, or any witness for that matter. But I mean, this is privileged material, and that Mr. Bailey wants to get into. And the real thrust of his cross-examination on this is whether $100,000 was really drummed up in costs or not. That's a privileged issue. Would the court permit us to go into how much a witness who testifies in this court who happens to have a lawyer is paying that lawyer to represent them as a witness in this case?
Yes.
Wait a minute.
Rosa Lopez, we talked about it, remember?
But did we?
Fee arrangements, remember?
But they didn't assert it.
That's true, but I allowed the inquiry, didn't I?
Only after they conferred. That was cleared first. I remember Mr. Darden went over to Carl Jones, went over to Carl Jones and asked him, hey, I'm going to go into the fee arrangements. Carl Jones waived any privilege and said that was fine. He did not assert the privilege, and he could have. He was given every opportunity. The court flagged the issue for him, and he elected not to do so.
As I am doing here.
Is that?
So we want Mr. Turtle down here, Your Honor?
Is that?
Well, I don't think that, Ms. Clark, with all due respect, I don't think you're in a position to claim the privilege on Detective Furman's behalf.
No.
So either Detective Furman himself has to claim the privilege or his attorney on his behalf.
I think probably it'd be most appropriate if his attorney did so, Your Honor.
Have you heard on waiver, Your Honor?
Well, let's hear from Mr. Tortolo if he's available.
May you just shut the hell up, please? Hi, Nan. Hi, Pumpkin. Marsha just stuck her foot in her mouth big time there, guys.
It's different here. With respect to Rosa Lopez, Carl Jones was representing her in her capacity as a witness. No other capacity. She wasn't filing any lawsuits. She had no independent legal cause of action going. And Detective Furman does. Because he's not being represented by Mr. Turtolo.
Well, but the testimony so far hasn't been that Mr. Furman has not filed any lawsuits yet.
That's right.
So there are no causes of action pending, are there?
That's correct.
Same
But-
difference.
No, it's not. No, it's not. Not at all. Because Mr. Turtolo is representing Detective Furman with respect to what may be filed,
Ms. Clark,
and it has
right.
nothing to do with...
Hold on. The issue is there somebody plausibly who can raise an attorney-client issue here regarding the area of costs? Maybe. That's what I've determined thus far. I'd like to hear from Mr. Tortolo. So rather than argue apples and oranges between Rosa Lopez's situation and Detective Furman's situation, it's an interesting discussion, but I don't think it really bears upon the specific issue regarding this letter.
that Mr. Torlow claims victory based on your rulings, if that's not representing a witness. I don't know what it is, but it's in the body of the letter. He took credit for rulings you made in Furman's favor.
What? No one gets to take any credit except Your Honor for Your Honor's rulings.
We've won 2 recent victories.
No, I don't score it that way either.
You don't score it that way?
No.
No.
First Judge Ito denied the defense team's right to review marked record. That's one of the victories.
Ms. Clark, did Ms. Lewis step out to find Mr. Tortolo? All right. Yeah, Mr. Bailey, I understand this is about the last area of inquiry that you're going to make at this point.
Remember when the judge told the jury it was only going to be 5 minutes? Ah, good lie, good lie.
You would like the parameters of the inquiry?
No. I'm just saying this particular issue is the last issue on cross, unless something leaps out at you overnight.
The phone keeps ringing. Something just came in. But it is, so far as I know, except for a question prompted by the last phone call, which is very brief.
All right.
Counsel intends to go into another impeachment witness.
No, I was just trying for scheduling reasons to see maybe we could at least wrap up the cross today.
Right, I appreciate that, but I'm talking about discovery reasons.
Listen, I know you guys say they played a tape or a video of Furman saying all these things, but gosh, you'd think we would have heard it by now, because this is it. This is the last of him. We're almost done with him.
Well, if we're going to wrap it up, I assume there's nothing more to discover.
Why would you assume that, Your Honor?
Well, I guess that was more wishful thinking.
Mine too.
Yeah.
But if counsel is referring to another witness that they intend to proffer, the people are entitled to know about it.
I am not.
All right, Mr. Tortolo.
Good afternoon, Your Honor.
Good afternoon, sir.
So I wear a tie.
Mr. Tortolo, are you familiar with the letter dated September the 21st, 1994,
Yes.
addressed to a Daniel Lobato of the Northampton Police Department?
Yes, I am, Your Honor.
All right, the issue has been raised in the cross-examination of your client, Mr. Furman, concerning any potential monetary interest he may have in the outcome of this litigation. And this letter has been proffered to the court as some indicia of monetary interest in the outcome of this litigation. And specifically the issue of the paragraph that indicates that your law firm has been fronting, so to speak, the out-of-pocket expenses that have reached over $100,000, and Mr. Bailey has indicated he wishes to cross-examine in that area. And in our discussion, prosecution has raised an objection of relevancy and 352, an undue consumption of time, as to that issue. And I don't recall specifically who it was who also opined that there perhaps is an attorney-client issue regarding the specifics of the representation, the parameters, the costs, and that sort of thing. And there's also a potential of waiver if, in fact, this letter itself was published and constitutes a waiver of that.
Well, number one, I will represent to the court that we have expended, including attorney's fees, in excess of $100,000 as of the date of that letter. That's number one. Number two, I will represent to the court that Detective Furman, to my knowledge, has never seen the letter. I have never given him the letter. I asked him if we could send out a letter to cover secretarial expert fees, investigators, and paralegals. If the letter isn't clear, I'll make it very clear. We have made it an arrangement with Mr. Furman that we were not charging him 1 cent. We have not charged him a penny. We do not intend to charge him a penny. And that we were doing it pro bono. And that's what the letter is meant to imply. But we cannot continue, as of September, we could not continue to front and put up all of the costs that we've been putting up in paralegals. Your Honor, we do claim the privilege. I wanted to explain why. I really appreciate Ms. Lewis's help, but I did intend to claim the privilege. But I wanted.
Geez, I wonder what Miss Lewis just said to him, guys.
I wanted to explain because I've been in front of the whole world accused of mail fraud, which is outrageous statement. And I will tell the court, as an officer of the court, we have expended over $100,000 as of the day of that letter. And the insinuations and accusations by Mr. Bailey are outrageous, and I resent those. But we do claim the privilege.
Oh, I should not say this, but I'm going to. I should not say this, but I'm going to. If that's mail fraud, whoa, our current president is in a lot of trouble.
All right, and you want to explain to me how it is that you feel expenses and expenditures on behalf of a pro bono client fall within the privilege?
The services rendered, whether they're pro bono or they're for a fee, in the description of services are certainly privileged. What we checked into with respect to the outrageous character assassination that the detective has been subjected to in the last 9 months and the work that we've done is definitely privileged. And our preparation in connection with potential defamation suits is privileged.
All right, thank you, sir. Mr. Bailey, do you wish to respond to that claim of privilege?
I certainly do, Your Honor. It appears that the letter is in fact fraudulent. I'm now told that it is to cover fees. The plain language, which every lawyer understands as unequivocal, is out-of-pocket costs have exceeded $100,000. Now, we're pro bono, we're covering fees, and we're out of pocket. None of this letter, apparently, is true in total. But as it relates to the witness, this office, if they're acting pro bono on the one hand, nonetheless purport to represent him in a money damages claim for defamation to be brought when this case concludes and not before, based on correspondence we've received on behalf of Detective Furman. I've seen nothing to suggest that the $100,000, whatever it was, if it was, is segregated out as for representing Mr. Furman as a witness. And I contend that this letter says that they're representing him as a witness and, in fact, have won two important victories that relate to rulings you made, relating to military records and his LAPD personnel records. We also know, and we don't know of any contingent agreement, that lawsuits are being prepared because counsel says they're being prepared and the witness, more importantly, says that they're being prepared. Now, how much of this money to be received from the solicitation is applied to the lawsuit where normally the client pays the costs, even in a contingent fee arrangement, is not specified. But I think it a fair avenue of inquiry. And I think the test is, if the $100,000 comes in, does any of that inure to Mark Furman's benefit? And did he expect it to when the letter went out? And is it not solely because of his position as a witness in this case that the solicitation was made with the hope of it being successful? If the answers to those questions are yes, I think waiver is patent in this case. When you go out representing to people through the United States mails that you've spent $100,000 on experts, investigators, and paralegals, an ongoing expense, that's a pretty serious allegation, and it is supposed to be, under federal law, completely truthful. I still doubt whether or not out-of-pocket went that high at any time prior to September 21, but I don't know. Ms. Clark alleges that she knows and assures the court that it did. I would like the opportunity to ask Mark Furman if any accounting has been given to him as against future obligations he may have in these civil lawsuits, or as against any fees that may have been charged, because we just heard that fees were included, by the Tortolo firm, and what he understands his position to be vis-a-vis the successful production of money from the police officers who are being asked to give it, like Daniel Lobato and the people in Oklahoma. That's what I think the cross-examination should be allowed to touch.
Your Honor, I have not represented Detective Furman as a witness. I've never discussed his testimony, ever. I represent you as an officer of the court. I haven't been present at any meetings, and I have had no conversations with Detective Furman regarding the facts of the case, purposely. My representation has been as a result of the incredible character assassination campaign that commenced in July with the New Yorker article. And that's it. And to say that part of our work, the assumption Mr. Bailey makes, had to do with preparing him as a witness is ludicrous. Again, I represent to you as an officer of the court, I have never discussed Detective Furman's testimony with him, nor have I discussed the facts of the case with him.
All right, well, the factual issue, Mr. Tortolo, though, that I need to resolve is whether any of the funds that were anticipated or received in response to this letter of September the 21st, and I take it this was a mass mailing, whether
No,
any...
there were like 425 or something. I don't know how many there were. We had very little money. But I do want to say this. I represented him as a police officer, and under the Constitution of the state of California, a police officer has a right of privacy, and it's a separate right. And he has a right to have a private attorney come into court and defend his rights of privacy, which is what I did before you.
Mr. Tortolo, before you launch into that, let me finish the question to you that I was trying to ask.
I guess there's been a lot of those problems in this courtroom stuff.
Yeah, it seems that way. Mr. Tortolo, the question I have is whether or not any of the funds that were generated or anticipated to be generated by this letter, did any of these go to the direct benefit of Detective Furman?
Absolutely none.
Can you explain to me how that is?
Because it goes to my benefit. I'm the one that's out the legal fees. I'm the one that's out paying my associates and my paralegals and my secretaries. Mr. Furman is not obligated to pay 1 penny, not 1 cent. And therefore, the benefit is to me, who's doing this work, and to my partner, Lori Butler, and to our firm. There's no benefit to Detective Furman. Detective Furman, whatever happens to this case, is not going to owe a penny to us. I'm doing it pro bono.
All right. Any other comment, Mr. Tortolo? Is that it?
I claim the privilege, and I'm ready to leave if you...
And I'm ready to leave with you.
In fact, I'll catch the next plane to Hawaii if I could get someone to go with me. No, they'd love it. His comment was, please do, but...
No, I said it was a good idea.
Yeah.
I still think so.
I'm sure he does.
All right. Well, today's been a pretty contentious day.
Look at color of your
All
star.
right. Any other comment from the parties,
Look
Mr.
what you
Bailey, Ms.
did.
Clark? Certainly.
Look, Fozzie's is the same color. Look, 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 look.
I think that eventually, I know loath as the defense is to let any detective off the witness stand, at some point, we have to. And if we get into this letter, this is going to be another, look at what it just caused now. Just to claim a privilege, just to argue the issue.
Well, we were lucky
spent-
Mr. Tortolo was in the building.
We were, and we are. But just under 352 alone, the consumption of time to go to an issue that is basically a privilege matter, because the heart of it is a privilege matter, to impeach someone's credibility has no impeachment value on Detective Furman. He has no benefit to gain from this letter. His lawyer hopes to be made whole by it because he has expended so much time and effort on his behalf with no recompense. And that's all you have here. So the bias and motive issue, which is what this should be going to, is non-existent. So the letter is really and truly irrelevant, in addition to being privileged.
All right. Mr. Bailey, any last comment after Mr. Tortolo's comments?
Well,
Yo, if he lets this letter in, I am going to lose it. He can't let this letter in. He just can't. We heard him say nothing goes to Furman. Not one penny goes to Furman. If Ito lets this letter in, I am going to lose it. Whew. Yeah, so that's what I said when I started this stream today. Said, take your blood pressure medication. There's no way. I'm sorry, there's no way. I'm sorry, there's no way. Here we go. Let's find out. Here we go.
I think I've expressed, Your Honor, the fact that even if nothing more, Mr. Furman is getting a free lawyer, if he is. And that, to me, that's very cloudy, by virtue of this solicitation, where he would not have gotten a free lawyer perhaps if he hadn't authorized the solicitation. That is a financial benefit sufficient to warrant cross-examination.
All right.
But he had a free lawyer long before.
Thank you, counsel. The issue of cross-examination and the extent of cross-examination is something that, thankfully, the appellate courts have rested significant discretion in the hands of the trial court. And in some areas, when we deal with, say, for example, racial bias, the courts have indicated that I must give either side wide latitude in cross-examination on racial bias and those issues, and the court has done that. This is an issue of financial bias, and given the representations of Mr. Tortolo, the financial interest of Detective Furman with regards to this particular letter is remote, and I find it not to be relevant. Were it to be relevant, it would cause an undue consumption of time, given the various issues that are here, and the claim of privilege also goes to the heart of the letter. So the prosecution objection will be sustained.
The questions and answers posed by Mr. Bailey.
You know, yes, the judge ruled correctly, but I'm still pissed. I mean, I'm already pre-pissed. And even though it didn't happen, that pre-pissedness is still there. Only because I almost expected Ito to let the letter in, because that's the way he's been going so far in this trial. That, you know, it was almost a given that, yeah, he was just going to let the defense have this completely illegal letter. And he didn't, but it's too late now. He's already pre-pissed me off for any ruling, even if it's fine.
Bailey yesterday, in advance of our having been given the opportunity to see this letter be stricken from the record.
No, he was allowed to cross-examine on whether or not Mr. Furman contemplated legal action against the lawyers in this case. That's fair cross-examination.
Right, no, but he also asked about the letter. That's what I'm asking to be stricken.
I think there's only, if you can show me where that is in the record, I think there's only a question or answer that's pretty innocuous, and we stopped at that point with the purpose of getting the letter to examine it.
All right, may I readdress that with the board after I've found the passage? If that's the case, then there is no point. But
I have to tell you, my recollection of it is that it's so innocuous that I'm not really inclined to stir the pot anymore.
Very well, Your Honor. What I'm concerned about is final argument, though, and addressing an issue that the court has deemed to be irrelevant under 352.
Well, if there's no letter to argue, then I suspect it won't be argued. Given the panoply of issues that are here to argue in final argument, a passing reference in 2 questions and 2 answers, I suspect won't carry the case. If you disagree, look in the record.
Damn it. I was so mad at the judge, and then he used planopy in a sentence, and now I love him again.
See what you think.
All right.
I'm just not inclined to address what I consider to be such a minimal issue at this point. Maybe if I think about it tomorrow morning, maybe I'll think about it differently, but I got to tell you at this point, I'm not real persuaded.
All right, let me look it up and see if it is worth it. I appreciate it.
Okay.
May I learn, Your Honor, whether this is anyway identified for the record?
It should be. The clean copy will be identified as Court's Exhibit next in order 8. 8.
May I be excused, Your Honor?
Yes. Thank you, sir. Do you have anything else you wish?
3 o'clock, Your Honor, I'd like a chance to, we have information coming in as we speak. I'd like a chance to confer with my colleagues before we decide.
All right.
The only remaining question is, I have a question I can put today. If you want to save that much time, it's about 3 minutes worth.
Not to drag the jury out and then send everybody home. All right, Deputy Magner, let's have the jury. I'll excuse them. And do we have any DNA lingering issues today?
If you could,
An afternoon without DNA. How wonderful. Okay. For an item led to argument, led to having to have another attorney on another issue come in and discuss it, and we've managed to take up the whole court day. This is also would ordinarily, given the situation, I would try to forge ahead a little bit more, but we have an activity planned this afternoon, so I'm going to break at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form.
I know what the activity is, but I don't know what they're called. You know that game where you go outside and on the lawn you put, I don't know, it has 2 posts and then like 1, 2, 3 poles going across. And then you take these 2 balls on a string and you throw it and you try to get them to wrap on the post. What is that called? It's very fun the more you drink. That's the activity that they're doing, whatever that is. I'm going to try to Google it, see if I can figure it out.
Form any opinions about the case. Don't allow anybody to communicate with you regarding the case. Don't conduct any deliberations till the matter has been finally submitted to you. We'll see you here tomorrow morning, 9 o'clock. All right? We'll stand in recess. And Ms. Robertson? Present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey. People represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. And before we begin this morning's session, the court would like to take the personal opportunity to wish a happy birthday to Ruth Archie, who is one of our regular audience, and on her birthday today. All right, counsel, is there anything we need to put on the record before we join with the jury again? Mr. Bailey.
yesterday there was a question raised as to whether or not I had spoken personally to a witness named Max Cordoba.
When Facebook deleted my account last week, the week before, I don't remember. They then charged me for an advertising campaign that I was doing like the day after they deleted my account. So I couldn't get into my account to cancel this campaign, right? So I called my bank and I'm like, hey, I need this charge reversed, this Facebook charge. No, they deleted my account. Now they're charging me. So they did. They refunded me my money. And then they canceled my card and sent me a new one. No, it's not Zimzam. It's Ladderball, like she said. So now every account that I have that used that card, I have to go in and change to the new card number. And it's a pain in the ass.
And that question arose from a mistake Mr. Cordoba made when being questioned on Dateline. NBC yesterday at various times during the day and Dateline itself last night corrected that misstatement. They found Mr. Cordoba in Phoenix, and he recalled that briefly while Mr. McKenna was interviewing him about the facts of the case that I had spoken with him about his appearance. And I would simply like, because the prior version is now a part of this case to a degree, to show the court, who I gather has not seen it, and the record that such an event took place, if I may.
You may.
And Mr. Harris, this is from last night's Dateline, and I personally taped it.
I take it there's no foundational objection. Thank you.
Hasn't located the spot. Perhaps that fact is sufficiently notorious so that it does not have to be played, the retraction, so to speak, by,
All right, well, Mr.
The
Bailey, I
witness.
just wanted to give you the opportunity.
I appreciate that, but I don't want to hold up the jury any more than we have. I'll simply make that assertion. I take it from lack of any contradiction that at least some members of the prosecution are familiar with the change in position by the witness.
All right. All right, Ms. Clark, anything else before we proceed with the jury? Is there anything else you wish to, any other comment on the record before we invite the jurors to join us?
I'll tell you why. Since you asked, my Facebook was fine. Everything was fine. I had a private chat, Facebook chat group with my family. And in there, I posted a link to a protest that's happening June 14th. Something like kick out the clown or something like that. And I sent that link to my niece. I think it was just my niece, and I don't know because it's all deleted now. I think it was just my niece. And then, boom, I saw in my chat a couple things. My posts were deleted. My text messages in this chat were deleted. In each spot, it said that I went against terms of service. This account has gone against terms of service over and over and over, and then gone. The whole thing gone. You can't even go to my page. It's gone.
I would only indicate, Your Honor, that in view of the more recent statement of Mr. Cordoba, to which Mr. Bailey refers, and I'm familiar with it, the real issue is Mr. Cordoba's credibility, and I think we should turn our attention to that and get on with this in a professional manner.
All right. It would thrill me to death if counsel would apologize to each other for the rather high level of vitriol yesterday.
Although I cannot say, Your Honor, that substantively speaking, the record, the evidence, and the information we had did not support the fundamental belief that we have a witness here who is not to be believed, who has no credibility.
Ms. Clark, forgive me for interrupting you, but given the state of the record as we know it today, given the level of the comments yesterday, which were not appropriate, I think it would be appropriate to begin this session by both sides acknowledging going beyond the bounds of professional conduct. In the heat of battle, I understand, and that we all agree to conduct ourselves.
Oh, deja vu, guys. Deja vu. Remember when Dearden had to apologize and he didn't? And we went through all this shenanigans. I suspect Marcia understands what the judge is saying. She is just going to apologize and move on. And I suspect the defense team is going to do the same thing.
Professionally today. And I only ask that of you first because you're standing and talking to me. I'm going to ask the same of Mr. Bailey as soon as I hear from you.
And I do.
All right.
No, I'm serious. No, I'm sorry, Your Honor. I'm not going to be facetious. I do mean that. I really do. I don't like to engage in that sort of exchange. I think it is, I think it's unseemly. I think it's bad for the entire profession. And I do extend to Mr. Bailey my apology for the extreme nature of the exchange yesterday. I don't anticipate that happening again. And I think that we will all, from this day forward, conduct ourselves as professionals, seasoned professionals that we all are.
Thank you, Ms. Clark. Mr. Bailey?
I, without hesitation, apologize for what I have found as an unwarranted comment directed at Ms. Clark, and that was that her eyesight and memory were deficient. Very plainly, that was unfair, since her eyesight is excellent and her memory has proven to be the same. My apology, most profound apology, is directed at the court. I've been doing this for 40 years. I was caught off guard with that accusation. The reaction was less restrained and certainly less professional than it should have been. And the thing that pains me the most is any criticism that has been directed at the court because of conduct of counsel. In my view, you're one of the finest trial judges I've ever had the privilege to appear before, and I think that criticism is unwarranted, and to the extent that I caused it, I do apologize.
Thank you, counsel.
May I join in that, Your Honor? I was not even aware of criticism being leveled at the court. If that is the case, I really would like to take this opportunity to indicate that we, from the prosecution, do not share in that view at all. We extend our most sincere apologies for any ill reaction that was caused by our conduct yesterday to the court. It was certainly unwarranted, unfair, and unjustified.
Well, counsel, I appreciate that thought. However, that's why I get paid the big bucks. All right, let's proceed. Deputy Magnero, let's have the jurors.
As we wait with the jurors, so that the record is clear, the people do not intend to call Max Cordova. He is off our witness list as far as we're concerned.
All right. Has now joined us, all of our members. That Detective Furman is again on the witness stand under cross-examination by Mr. Bailey. Good morning, Detective Furman.
Good morning, Your Honor.
Detective, you're reminded you were still under oath. Mr. Bailey, you may conclude your cross-examination.
Detective Furman, do you recall that yesterday I indicated a certain area of the audience and asked you if you saw anyone there that you knew? Recall that?
Yes, sir.
And did you see anyone that you knew?
That I knew?
Yes. Yesterday.
I know people, yes, in the audience.
No. Someone
Yesterday?
Someone that was connected with the preparation of your testimony.
No, I didn't recall, no.
Did you see anyone when you looked out yesterday, not here today, who was connected with the preparation of your testimony?
No, sir.
You did not?
No.
Do you know a Dr. Mark Goulston?
It's a different name than I heard yesterday. Overruled. Excuse me, counsel. Objections?
Objection as amended.
Item 4. I heard a different name. Overruled.
I know a Mark. I don't recall a Mr. Goldstein.
Goulston, as I get it.
I still don't, sir.
And who is Mark?
I believe he is a doctor.
Psychiatrist, is he?
I'm not sure if he's a psychologist or a psychiatrist.
Okay. And under what circumstances have you seen him?
I've seen him in the DA's office.
Was he present during the grand jury session?
No, I don't recall him being there, no.
Has he talked with you at all about being a witness?
No.
You've never had any conversation?
Yes.
What have you talked about?
We didn't talk. He just said, you're doing a good job. Keep it up.
Did you talk to him before you testified?
No, not at all.
And he's had no conversation with you at all about the manner of your testimony, except some words of encouragement after the fact. Is that the way you leave it?
Yes, sir.
Did you recognize him when I pointed to him yesterday? Sitting next to Mr. McGinnis?
Assumes facts not in evidence.
Did you see me point yesterday in this direction?
I believe you pointed, yes, sir.
All right, indicating the back row of the seats reserved for counsel and the audience.
Mr. McGinnis is the landmark since he always sits there. I believe the man was sitting next to Mr. Joe McGinnis. That's where I was pointing. Mr. McGinnis, Detective Furman has his hand up. He's the tall gentleman, gray hair.
Yes, sir.
Was Mark Goulston sitting there when I asked you the question?
Objection.
Oral.
I did not notice him, no.
You didn't notice him.
No.
How many times have you seen this man, Detective Furman?
4 or 5 times.
Okay. Detective Furman, how did you call in the license plate of the vehicle that turned out to be Kalen's on the morning of the 13th?
Police radio?
Is that called a Rover?
Yes, sir.
Is that something you carry on your belt?
No. You could, but in plain clothes, it's very difficult, so you usually just take it out of the car and hold it.
Okay. Did you have it with you that morning?
At different points, I did, yes.
All right. Did you have it with you when you were in talking to Cato in his bungalow?
I don't believe so, no.
Did you have it with you when you went out to look for the source of the noise?
No.
Do you have any communications equipment with you at that time?
No.
Infinity
Detective Furman,
and beyond.
is there a police radio code where certain words are used to indicate letters of the alphabet, as there is in aviation and the military, for instance?
Yes, sir.
What's the police word for N?
Nora?
V,
Victor?
N,
Nora?
H,
Henry?
I.
You put me on the spot. Oh, it's Indio in the military. I'm having a... Ida.
Okay. Does NVN have a meaning to you?
No, sir.
Do you use that on the radio at all?
No, sir.
I mean the phonetic letters, Nora, etc.
Oh, the phonetics, if I'm running a license plate, such as that?
No, no. You said V was represented by...
Victor?
All right. Do you ever use the term Nora Victor Nora when talking to other officers on the radio?
Why would I do that?
Do you ever use the term Nora Victor Nora talking to officers on the radio?
Please don't get me demonetized again, or not demonetized, but limited. Please don't say it. Don't say it. You don't have to say it. There's anything else you can say but that to mean that, but don't say it.
Radio.
No, sir.
All right. Thank you. That's all I have, Your Honor, until the other matters are settled.
All right. Redirect. Ms. Clark?
I can't pick and choose history. I
Thank you,
can't.
Ann. Detective Furman, I'm going to direct your attention to your state of mind and knowledge at the time you stepped out the front door at Rockingham. That means, and by that I mean after you placed Cato Kalin at the bar and then walked out the front door to go out to the south pathway. At that time, sir, the first time you walked out to the south pathway at 360 North Rockingham, did you know the time of death for Ron Goldman and Nicole Brown?
No, ma'am.
Did you know whether Mr. Simpson had an alibi for the time of their murders?
No.
Did you know whether there were any eyewitnesses to their murders?
No.
Did you know whether anyone had heard voices or any sounds or any words spoken at the crime scene at the time of their murders?
No, ma'am.
Did you know whether Cato had already gone up the south walkway before you got there?
No.
Did you know whether any fibers from the Bronco would be found on that glove that you ultimately found at Rockingham?
No.
And did you know the cause of death?
No.
I have nothing further.
Mr. Bailey?
Nothing, Your Honor.
All right, Detective Furman, I'm going to release you from further testimony today. However, you are still subject to recall. You are ordered not to discuss your testimony with anybody except your own attorney and the attorneys from both sides or their investigators. Do you understand the order, sir?
Yes, Your Honor.
All right, thank you very much. Your excuse, sir.
Thank you.
Ms. Clark? I'm sorry.
Maybe have 72 hours on
Whatever they're about to quibble about, we'll find out tomorrow. We're good for today. Thank you so much for coming out, guys. I really, really appreciate it. I love watching this trial. I can't wait till it's over, though. We did bite off a big one, but it's fine. We're gonna get to the end of it. We are. And I shall see you all really, really, really soon. Bye, guys.